Good evening to those who have been admitted and have joined so far. We 5 minutes from 6 o'clock. The webinar is due to start at 6 and will run through to 9 o'clock. We are going to allow an extra 5 minutes before we start the webinar, just for any latecomers to be admitted and for them to just get themselves properly into the webinar. So we will start at 6:05. We'll try and finish at 9 o'clock sharp. We will also try to make time for questions as much as possible. I know there are a lot of questions. And then we will take a break after each hour. So the schedule will be that we will run for approximately 45 minutes, take about 10 minutes of questions if there are. If there aren't, then I'll just continue with more information and then take a short break at the end of each hour and then start again and run roughly along those lines. We'll see how it goes. Thank you very much to everybody. Can everybody please just make sure that they've muted themselves? There are quite a few who are not on mute.
Hello.
Please can everybody make sure they mute themselves.
Hello.
Stop doing what I'm doing.
Just to all participants, I've muted you all. If you are called upon to speak, you're just going to have to unmute yourselves before you speak, please. Good evening. It's 6 o'clock. The webinar is due to start at 6. We're just going to give participants another few minutes to join. We're aware of a number of people that are just having a technical challenge of one sort or another, just helping them to get onto the webinar. But we're hoping to start within the next 5 minutes. Just for those that are in at present, we're just waiting for one or two last participants. I think there's one more we're just waiting for. Just be aware that you have been muted. If you do want to talk, please unmute. Remember to unmute yourselves before you start talking. We are going to encourage interaction. It's up to you. You've got an opportunity to interact on the topic this evening, and ask any question relating to court skills for experts that you would like to ask. We're just going to give it another minute or so, and then we're going to start the webinar. Good evening, everybody, and welcome to the webinar on court skills for expert witnesses. We are going to be running for approximately 3 hours. There's a lot to cover, but we're going to try to get through as much as we can to address most important points on this topic. I'd just like to start with one or two announcements. Just firstly, just on a technical note, you just have heard that if you are called upon to talk, please remember to unmute yourselves. There are a number of issues relating to, sorry, there's one last person that I'm admitting now. Just bear with me. And then everybody should be in. All right. And then just on another technical point, for those that are wanting CPD points, which I take it will be most of you, please make sure that you get your relevant information to Zita in good time so that we can process those points efficiently. We do one batch of processing, so we've got to wait for everybody to finish providing us with information before we can submit for anybody. So please just help us by cooperating in that way. I take it that everybody's on the WhatsApp group. If you're not on the WhatsApp group, please, at the end of the webinar, please will you just send a message or send it during the webinar. We'll pick up on it if you're not on the WhatsApp group. Very important that you're on the WhatsApp group on court skills for expert witnesses, because there's information flowing backwards and forwards, for instance, around CPD points and a couple of other technical aspects as well. All right, let me just introduce myself. For those that don't know me, my name is Ian Dutton. I'm a practicing advocate, and I have been practicing as an advocate now for as an advocate or an attorney for almost 30 years. I have 25 years experience as an advocate, and my main area of expertise is personal injury work. And within that subset, I work a lot with expert witnesses and have done that for the last 30 years. And have found that a tremendous challenge and a great pleasure to be involved with that. So, arising from that, there are numerous questions that I get asked on a regular basis relating to expert witnesses, and a number of issues which people should be aware of, but really there's just very little scope for them to be properly appraised of what they need to do as expert witnesses in court. This evening's webinar seeks to address those issues in two ways. Firstly, what we intend doing is going through, giving you an overall picture of the litigation process itself. So breaking it up into the various stages of litigation. It's not a formal analysis of the litigation process that you'll find, for instance, in the rules of court, but it's a very useful way of understanding the overall picture, how the litigation process starts, how it runs through the various stages, and then right at the end, how it ends and it culminates in a resolution of the litigation. Now, that process for this evening is taken very much through the lens of the expert witness. So this is to put that process in the context of an expert witness who may come in to that process at various times, and you'll see that there are various stages that the expert actually slots in, but then disappears from the picture. And the first important point is that the expert witness, although he or she comes and goes, it is important for the expert to have some orientation as to how their role, even though they're on and off stage, what's happening with the play overall, the thread of that play and the development and the various characters. And that's the first thing that we're going to do, is to give you an overall view of what's happening. And then within that overview, we're going to have a look at certain specific details that are very important for the expert to know. We base these details on strong theoretical foundations, but really the emphasis is on practice and on practical skills and on a practical understanding of the process. We will be referring this evening to the Expert Witness Guide, which I've written on the subject of expert witnesses. The Expert Witness Guide follows a similar theme in the sense that it starts off with what is an expert and understanding the role of the expert in the first chapter. The second chapter is a more detailed view of some of the principles governing expert witness evidence. Then we go on to the guide goes on to expert report writing, but really it's chapter 4. For those of you that have the Expert Witness Guide, it's going to be chapter 4 that we're going to focus on this evening. And that chapter 4 is appearing in court. Now, I say appearing in court, but in fact, you'll see that it's the entire litigation process with an emphasis on the actual court appearance tonight. Just for those, I've had one or two questions about individuals who may have bought an earlier version of the Expert Witness Guide. The earlier version, there are a number of editions now of the Expert Witness Guide, but there was also a version called the Expert Witness Manual and Casebook, which was brought out, I think, about 2 years back. Fear not, if you have any of the earlier versions, obviously there are updates in the later versions, but the book has been specifically structured so that sub-paragraphs remain consistent. So we've really tried to keep the sub-paragraphs as they originally appeared. And so we will, when I go through the page numbers, I will also obviously refer to each particular sub-paragraph, which will be which then will allow you to follow if you have earlier editions or the Expert Witness Manual and Casebook. So all of that will still be relevant. I just want to then also, before we get into the formal structure, I just want to clear one preliminary point out of the way. And that is the role players in court and the identity of who's who in the court. The majority of cases in which you as medical experts will appear will be in the High Court, and I'm going to restrict myself to comments within the High Court. So the most important person in that courtroom when a trial is running is obviously the judge. And you refer to the judge as my lord or my lady, depending on their gender. But the important thing to appreciate about the judge, and really this must run through really everything that you do in that courtroom, is that is the person to persuade. And therefore, that is the person to whom you must address yourself during the course of the proceedings. You will be asked questions by the advocates, and we'll get onto them in a moment. But although the questions are coming to the advocates, don't get involved in a conversation with the advocate unduly. Or let me put it this way, don't restrict yourself to interaction with the advocate. Your primary point of attention should actually be towards the judge. And you should be watching the judge, and building a rapport with the judge is tremendously important for an expert witness. So you want to be building a sort of relationship with the judge during the course of that trial. Now, the reason for that is you must please remember, as expert witnesses, that you fulfill a role in which, by definition, because you are an expert, you have important knowledge which the judge does not have. If the judge had that knowledge, you would not be allowed to testify as an expert. That's dealt with in chapter 1 of the textbook. I'm not going to go through the details of that. For those of you that are interested, you can go and have a look at that, and it sets out that relationship between the expert and the judge. But the point for this evening that's important is that the expert witness is there in a position really, and I always urge my experts to look at it this way, to guide the judge. By definition, they have important information that the judge needs to understand properly in order to come to a proper decision in the matter. There will be times where you will be put under pressure by cross-examiners. There will be times where you're led by your own advocate. But whatever is going on in the courtroom, don't lose sight of the fact that you are there to assist the judge. It can be very intimidating appearing in court as an expert witness, as a lay witness, even as an advocate, can be intimidating. The important thing to do is to build that relationship right from the beginning. In fact, all the way back to your report, you should be building the relationship with the court. And what is it that you want to establish? You want to establish that the court can trust you, that it can rely on your opinion. And there are various ways that you do that, partly through demeanor, partly through the way you present yourself in court, partly through being obviously understanding your way around the court process, which we hope this evening will help you with. But ultimately, the real test is going to come in on your opinion and how well it is presented and how well it is connected to the facts. And in that regard, always remember that the evidence that you're given in the court, that you're giving in the courtroom, must fall within the four corners of your expert report. And that therefore gives you a tremendous assistance when you're testifying. Because if your expert report is properly drafted and properly thought through and properly based on the facts and unbiased and within your field of professional expertise, then you're going to find that that expert report will steer you through the process of testifying in court. That expert report will be your compass and your roadmap. And it is absolutely appropriate for you to refer to your report and to be guided by your report. And in fact, your advocate should be doing that and should be running through your report when he or she leads you through your evidence. We will deal with evidence in chief and cross-examination in some detail later, but for the moment, the important point is bear in mind that it's your expert report that serves as the foundation for your evidence in court. Just another point on that is, as the judge, there's a lot of information coming from the judge's point of view. Be aware that the judge can be overwhelmed by that information, especially highly technical information, medical malpractice disputes and the like. It's a lot for the judges to take on board. They will make meticulous notes of your evidence, but I can assure you that your expert reports will be looked at afterwards if there's any degree of technical challenge. And what's in your expert report, if it's well drafted and well set out, will supplement the evidence and the impression which you make in court. All right, so that's the judge. Just quickly going through the other role players, they're the advocates. There's the advocate for your side. There's the advocate for the other side. The advocates will ask you questions. Your advocate will lead your evidence, and we'll have a look at in more detail at what happens there and the appropriate way to deal with that. Advocate for the other side will then cross-examine you. There may be multiple parties, and you may then have to be cross-examined by multiple advocates. And then at the end of the cross-examination, there will be what's called re-examination. In other words, that's if there's any loose ends or points that need to be covered, your advocate will then get an opportunity to then try and put Humpty Dumpty together again if things haven't gone so well, or simply to highlight certain points and to accentuate where you have gone well. But again, your advocate will be quite restricted in what he or she can do during that re-examination. The other role players are the attorneys. The attorneys, you'll all be very well familiar with attorneys. They play an important role in the preparation of the trial. As far as the trial itself is concerned, they tend to take a back seat. The advocates, that's their field of expertise. When I started practice, you couldn't appear in the High Court if you were not an advocate. Attorneys weren't allowed. And I seem to remember that the jurisdictional limit in the magistrates' court, I seem to remember, was 1,000 rand. I certainly remember 3,000 rand. So any matter that was of greater value than 1,000 or 3,000 rand required an advocate. These days, that's changed quite substantially, but the advocates still are the main role players as far as the legal professionals are concerned when it comes to court and when it comes to preparing for that court appearance. And then you have the court staff. There are interpreters and translators. Obviously, with expert witnesses, that's not so relevant. One member of the court staff to be aware of is the judge's registrar, who's sort of the judge's PA, and will set the court up, bring the court file in, and your interaction when the judge is not sitting will be with the registrar through the advocates. You'll see the advocates engaging with the registrar quite frequently. Quite an important person, obviously, to be able to have a good working relationship as the judge's registrar. And he or she will come in with the judge's books and water and all that sort of thing prior to court starting. And then you have an usher who will then show people in and out of the court. And that really, those are the key members within the courtroom. Just before we move off that topic, a point that I'm sure your advocates will cover with you, but something just to raise at this point is when you're giving your evidence, remember that everybody in that courtroom needs to hear you, including people who are sitting in the gallery. The gallery is the public area, and there will be people who are interested in the case sitting in the gallery. And a very good rule of thumb in that regard is to project your voice to the furthest corner of the courtroom. So sort of talk to the furthest corner of the courtroom as far as the volume of your evidence is concerned. That's a very handy rule of thumb. And remember that when you start giving evidence, the volume at which you start giving your evidence will be, you'll sort of get used to that, and then that will become the default volume of your giving evidence. So provided you're not shouting, project your voice nicely and quite loudly. The judge needs to hear clearly what you're saying. And then that's the other point about your delivery. Please, when you are in court and you're testifying, I've done a little video on it, but it is so important. Watch the judge's pen. He or she will be making notes. Almost every single judge will make manuscript notes in addition to the proceedings being recorded. But the important point, there are two important things that flow from that. Firstly, if you watch the judge's pen, and as they are making notes, as they get to the end of the bit of evidence that you've given, they will look up and make eye contact with you or nod or something to that effect and give you an indication that you can now carry on. What's important about that is, firstly, the judge is taking down the evidence that you're giving and has got time to think about what you're saying and make legible notes. Those things are sometimes difficult to do for a judge if a court is if a witness is sort of running away with himself. So that's the first thing. You'll get the pace right. And that then will mean that the judge is comfortable with the pace at which you're giving your evidence. The judge feels relaxed that he or she is sort of in control of the process, can internalize what you're saying, understand what you're saying, and can then direct questions or even pause and think if necessary. So that's the one important thing about watching the judge's pen. The other important thing about watching the judge's pen is that it builds in a very subtle way, but a very effective way, builds a rapport with the judge, between yourself and the judge. So by watching the judge's pen, you immediately sort of orientate yourself towards the judge as far as your body language is concerned. You're watching the judge. You're picking up on subtle cues. Like the judge may be a bit confused about something, you'll see that. Or the judge may be very interested in something, you'll see that. And it draws you away from that sort of locked-in relationship where you're just talking to the advocate all the time and not building that rapport with the judge. So that's a very important practical tip. All right, those are the role players. Let's just move on to the next slide. Just give me a moment here. I just want to sort something out technically. All right. So This webinar is presented for witnesses and legal practitioners to review the trial process and improve their preparation for and presentation of evidence during the course of a trial in order to present effective and persuasive expert evidence. Just to accentuate that, your goal is to provide persuasive expert evidence. You want to persuade the court on the point that you're being called for. Okay, your CPD points, there will be 3 ethics points I've dealt with. Please get hold of Zita. I'm not going to spend much time on that. And then as far as the overview is concerned, let's just have a look at those 3 stages. The overall process of a trial and how the evidence of the expert witness fits into that process can be described in 3 stages. One is your pre-litigation stage. That's, in other words, before summons is issued. Number 2 is the trial preparation stage. So everything from once the summons has been issued to the actual trial trial itself. And then 3 is the trial stage. Now, just to explain that to you, this breakdown of these 3 stages is really primarily used by lawyers to understand where they are in the process. But expert witnesses will be brought in at those various stages for different reasons. So, for instance, your pre-litigation stage, you could be brought in there for an opinion. This often happens in cases where you're dealing with medical malpractice. And the reason for that is that it's important before a decision is made whether to either sue or to defend a case of medical malpractice, that expertise is gained on, for instance, causation or negligence. So you will sometimes find yourself instructed to provide a report before there's even a decision to either issue summons or before there's even a decision to defend the case. So that's where you'd be coming in at the pre-litigation stage. It happens, there's a variety of that happens within road accident fund work as well, where the medical report is very important, RAF1 form, and the RAF4 form as well. You could look at as being sort of a variety of the pre-litigation stage. But when I say pre-litigation stage, I'm really talking about medical malpractice cases where you'll come in to provide an opinion. That's the usual way that it's done. The trial preparation stage we will have a look at in a moment. Okay, just to go back to the previous slide. Insofar as the trial preparation stage is concerned, there are various aspects that you will be familiar with, such as meetings of experts, joint minutes, and the like, and we will go through that in a few minutes. All right, now just insofar as the trial preparation, the trial stage is concerned, there are a couple of preliminary points I want to get onto before we really dive into the more technical aspect and the actual appearing in court. So the next point to deal with is what happens after the expert witness testifies, so other witnesses, closing arguments, and appeals. What happens is that you will be called at some stage during the course of the trial. For those that have actually appeared in court or that do regular appearances in court, you'll know that can entail a lot of waiting time, waiting around. Other witnesses will be called in a various order. It's one practical thing is it's very, very difficult as an advocate to know when an expert witness is going to be called, or even to know what order you're going to call your expert witnesses in, or even whether it's going to be necessary to call an expert. And the reason for that is that the whole litigation process, including the trial itself, is a very fluid process. So things are constantly happening during this formal, almost ritualistic exchange that goes on between the different parties and the judge. And so what happens is, for instance, a witness may go very well, and it might be a very effective witness, and at the end of that evidence, it may well be that the other side abandons a particular point because that witness has been very persuasive. And then it's not necessary to call expert witnesses that may have been testifying on that particular aspect. Alternatively, what might happen is that some avenue may get opened up that you thought was not open. There may be a dispute that arises where you thought the matter was settled, and it may even then be necessary to unexpectedly call an expert witness that you hadn't intended to call. So that's very important. I just want to go through after all the witnesses are called. What happens, and this is important for experts to be aware of, is that then once all the evidence is over, the advocates will get a chance to address the court and to present closing arguments. Now, those closing arguments are important because they are very often done orally, almost without exception, although there are occasions where only written argument is advanced. But normally there will be an oral argument, but almost invariably, if there's any aspect which is of complexity, there will also be written arguments. And in both the written and the closing argument, the oral argument, it is very important that the expert witness's evidence is well summarized and presented to the judge. And in a trial involving expert witnesses and expert evidence, that aspect of summarizing and presenting the expert witness evidence in a coherent way, in a way that fits the overall plan and structure of that trial, is very often decisive in that trial. This is important to be aware of as expert witnesses, because it is very helpful to an advocate when you're preparing your closing argument if you've got cogent summaries in your expert reports. It also helps in preparation for trial, but when it comes to closing arguments, those summaries then forming the foundation for the expert testifying well in court goes a tremendously long way in making it easy for the advocate to present an understandable and persuasive case to the court, and for the court to understand what it is that the case is about, what your side's version of that case is, what your case theory is, and how that particular expert's evidence fits into that case theory. So it's important to bear in mind that as an expert, you are part of a broader structure. And I know from your point of view, your evidence is you have a very close-up view of it. But you must be aware that your evidence interlocks with other expert witnesses, and it should be of service to the advocate as well. Once there's closing arguments, there'll be a judgment, and then the appeal process will then follow. Expert witnesses aren't involved in the appeal process. Appeals are done on the record, in other words, on the papers, and a transcript of the proceedings, in other words, a typed version of the proceedings, is then prepared and goes up through various appeal processes, which may take a number of years, particularly in more complex matters, which may go on to higher appeals. So that's the appeal process. What to wear when going to court? I am asked this on occasion. It really, the rule of thumb, and there may be specific provisions in various divisions, but certainly in KZN where I practice, and to my knowledge around the country, also the Eastern Cape, provided experts are dressed in an appropriately professional manner, and respect is being shown to the court. It's also important to remember that you're projecting yourself as an expert. So formal professional wear is acceptable. You don't have to really worry too much about colors, but try and avoid anything gaudy or bright. You want to come across as professional. For men, wear a jacket and tie. For ladies, just good sort of business wear is appropriate. We've been through the various actors in the trial, and then just lastly, just a point on how to address the court and advocates. I've already said that when you're addressing the judge, when you're talking directly to them, you say "my lady" or "my lord." And if you're talking to somebody else about them, like if you're answering a question from an advocate, it should be "her ladyship" or "his lordship." Then you'll hear advocates making these comments, referring to the judges that way. The way to address advocates is they don't really have a title. You can call them Mr. So-and-so, or you can call them Sir if you want, if you feel so inclined. I don't think it's necessary for an expert to call an advocate Sir. It's slightly, I think, it sort of strikes the wrong note, I think, slightly. But if that's your style and if you're comfortable with it, then that can be appropriate. The best way is to refer to the advocate Mr. So-and-so or Miss So-and-so and their surname. Or if you don't know what their name is, you just don't give them any sort of title at all. That's really the way around that one. Okay, and then just to wrap up on this session, the pre-litigation stage. So just to develop that for a second, from an advocate and attorney's point of view, there are three important things that happen at the pre-litigation stage. There's the initial analysis of the case, and that will probably or may very well involve expert evidence on the initial analysis. The client in those circumstances would be looking for advice as to whether to institute action or whether to defend action. And that was what obviously the initial analysis is designed to do, is to assist the advocate in providing advice there's a formal way that advocates provide advice. And then thirdly, alternative dispute resolution, and to consider whether alternative dispute resolution is appropriate. That always formed part of your advice, and it was very sort of really minor aspect of alternative dispute resolution. But more and more alternative dispute resolution is coming to the fore. Those of you that know me will know that I've been a mediator for the last 10 years, and that I've seen tremendous success with mediation within personal injury. There's a lot of debate about mediation at the moment, particularly in Gauteng. We will see what comes of that, and we're not going to get into that particular debate today. Save to say that the question of mediation is certainly coming more into the fore, and the question of whether a case can be successfully mediated or not may very well involve the input of an expert witness. So that is a point to be aware of. All right, and then we will get into, after the break, we'll get into the pleadings and the trial preparation phase. But I just want to check. There is a question in the chat, and I just want to have a quick look at this. All right, there's a question about copy of the slides being sent to all attendees. Yes, certainly we can make a copy of those slides available. And you will see that for those that have the textbooks, you'll see that as we move now, we will have references to the various page numbers. I think what I must do is I will also put in fact, I'll replace the page numbers with the paragraph numbers so that you can then work through those paragraphs in your textbook at your leisure. All right. Are there at this stage, any other questions that anyone wants to ask before we move on? Please just pop your questions in the chat, and then I will answer them if you've got anything that you want to ask, any clarity, or if necessary, we'll call on you to talk. All right, I don't see any questions coming through, so I'm just going to continue then for another few minutes, and then we'll take a short break. All right, just having a look now at this. So that really summarizes the first stage, which is the pre-litigation stage. The pre-litigation stage, before we move on from that, can be quite challenging. Just because it's pre-litigation, I wouldn't like to create the wrong impression and leave the impression that it's sort of a perfunctory thing. There can be very, very important decisions made at the pre-litigation stage. And if you are briefed or instructed to provide an expert report or some sort of opinion by one of the role players, particularly in medical malpractice cases, there are crucial decisions that could involve many millions of rands based on, very often, in large measure, on what guidance the legal representatives are getting from the expert witnesses. So that stage can be very important and shouldn't be underappreciated. But if we then have a look at the pleadings and trial preparation stage, the first stage there is really drawing pleadings. So once you've gone through your pre-litigation stage, there's now a decision made to sue, to institute action. Summons is then prepared, and there's a document called the particulars of claim, which will be annexed to the summons. And the summons and particulars of claim are the formal documents from the plaintiff's side. So that's the formal documentation that kickstarts the litigation process proper. There may be some preliminary notices, etc. There's the Rule 41A notice. There's the various forms of RAF matters. But the pleadings are a formal summary of the plaintiff's case as set out in the summons and the particulars of claim. These documents are very important to get right in all their detail. Cases literally turn on the language used in the pleadings. And in order to get the pleadings right in matters involving expert witnesses, it is often critical that the experts' reports or advice is correct in all its detail, because that detail then will, in one way or another, get incorporated into the formal pleadings in the case. And the pleadings, why this is so important is because the pleadings set out the respective cases of the parties. And the problem with not getting your case absolutely accurate on the pleadings is that you run into a difficulty if your case isn't exactly as pleaded, because the other side says, you're taking us by surprise, we haven't prepared for this aspect, and therefore we are prejudiced, and this expansion or deviation from the case should not be allowed. Very important to understand, and that is something that happens regularly in court. From the advocate's point of view, drawing accurate pleadings is absolutely essential. And when you're dealing with expert witnesses, what those experts are telling you forms an important part of your pleadings. So it is important that experts get those details right. There you get your summons is what kickstarts it, and then you get a plea, which is the sort of formal response by the defendant. There's more than one defendant, there are various pleas. There can also be further pleadings. I'm not going to get into where there are further pleadings. Those are not unusual, but they're not the common way that pleadings happen. It's not necessary for tonight's purposes to go into that. The other aspect that sits alongside the pleadings themselves are then the expert notices, which everybody is obviously very familiar with. Just for people that may still be finding their feet, fairly new to being an expert witness, what I would say is that your expert notice is absolutely critical. You already have picked up from what I'm saying this evening that your notice is the foundation of everything that you do and everything that your side's advocates prepare in respect to that overall case. So both regarding your evidence directly and also the evidence around your evidence. And remember, I said that's part of that process. So the expert notice is critical, must be done properly. Just insofar as the structure of that notice is concerned, I'm not going to go into the structure of the notice. That's a topic for another day. But what we can have a look at, if we look at paragraph 4.2 of the book, and I'm just going to actually put it up on screen. Oh, and I should also mention, it occurs to me that this video is being recorded. And so we will make that video available to anybody who wants to go through the video or make notes or anything to that effect. Anybody that couldn't attend tonight will also be given a copy of the video. That's absolutely fine. And just if you'll bear with me, I think what we can do now is let's just take a break for 5 minutes, and then I will load the text, and then we can resume. Let's have a look at what the time is now. It's 22. Yes, let's resume at about 10 to. So if we can start again at about 10 to 7. I will put my video off now. When you see my face back on screen, then I'm going to be preparing to continue with the next section. If you have any questions, please put them in the chat box, and I will try to address them. All right, it's going to give everybody 30 seconds to join. Okay. Just before I start this session, I'm just going to say that I've got a question to one or two questions. I'm going to let me just make my way through this session and then let me get to those questions. At the end of the session, I'll spend a few minutes on those questions. Let's get through this material because we may get some other questions that are relevant to those answers coming through. Okay, so just quickly, for those of you that have the book, so we're at on the Expert Witness Guide, we're at page 167 of that's the latest version, but you'll find at paragraph 4.1, I'm just going to check the that what I'm telling you is actually correct here. Yeah, 4.1 in yes in the Expert Witness Manual and Casebook. It's also that we've kept the paragraphs specifically like this so that when there are updates, the older editions are not outdated, so you can still it's still relevant. Okay, so we've had a look at the outline of the court process. We've been through 4.1.1 and 4.1.2. We've been through 4.1.1. We are now going to have a look at 4.1.2, and then we will have a look at 4.1.3 being the trial stage. Now let's have a look then at paragraph 4.2, and you'll see that it appears at page 168 of the book. So the Rule 36.9 notices. Now I've already referred a number of times to the expert notices. Again, just to, and I know I'm going to re-emphasize this. This is your absolute roadmap. This is your security. As an expert witness, you actually have a huge unfair advantage as a witness. And I say that because you're on your turf as an expert. The reason you're testifying, to repeat, your reason you're testifying is because the judge doesn't know this. Okay, so if you sit down and you prepare your 36.9 notice properly, and you've thought it through, and I will take you through the main avenues of attack in the third hour. We will go through the main avenues of attack, which advocates are taught to use and which we do use. And you make sure that you cover those main avenues of attack in your 36.9 notice. I can assure you that you are should be in a very strong position to testify. And I want to immediately make one point here. I've watched many thousands of expert witnesses testifying, okay? And I've watched terrible cross-examiners and I've watched superb cross-examiners. What I want to tell you about cross-examination is that, it can do damage, it can do terrible damage, but very often the reason that damage is done is because a very capable cross-examiner will start picking at details that actually, in a way, don't really matter. And what often happens, it's not the only thing that happens, but often happens, the witness sort of panics and starts making mistakes. And what I'm saying to you as an expert is just go back to your notice. If your logic is right, if your facts are right, if your reasoning is right, if you go back to your notice, even if you feel that you may be performing badly, if things are, you're in a torrid cross-examination, and that cross-examiner is picking at details that you're battling to deal with, and you maybe made the odd error, or you overlooked something, or you weren't aware of something. If you just stick to that notice, you will give something to, if you've got a competent advocate, you will give your advocate something to work with when it comes to that closing argument, when it comes to the appeal stage. This is why I took you through those processes. Because to you, it looks up close and personal. It's be all and end all. I can assure you, it's amazing in a trial. Something happens in evidence when you're cross-examining or when your witness is under cross-examination, and it seems like the whole case turns on this. And I can tell you, after a long trial, or even not such a long trial, a day or two, you can hardly even remember what that witness said because so much happens so quickly in a trial. So please look at your evidence in context. Don't get thrown out unnecessarily if things go wrong. You have to have a backbone as a witness. You need to have a brain and a backbone. And if you are getting buffeted about, remember your expert report is going to stand at the end of the day. You'll still be there, and your advocate will then be able to go to that expert report in closing argument and even on appeal and refer back to it. What is devastating is if you start deviating from your expert report in evidence and you start making concessions. Sometimes it's necessary to make a concession and then that should be done. But if you just roll over for no valid reason and just give in to the pressure being applied to you and you deviate from that expert report, the moment you make that concession, your advocate can do nothing about that. Because when that concession is formally made, any other advocate worth his salt or her salt is going to say, this was conceded by Mr. or Miss so-and-so. And once that happens, it's beyond, the advocate can't resurrect that. But if there's still debate about the point, and it hasn't been formally conceded, your advocate can still fight the point, argue the point, minimize it, put it in its right context, explain it away. There's a lot you can do to work with it if there isn't a formal concession. Now, there are times where you have to make a concession. You'll be driven to a point where if you don't make a concession, you're going to lose the credibility of the judge. And remember what I said. You have to build that rapport with the judge. But only in those circumstances should you make a concession. You should be reluctant to simply concede. So that's your 36.9 notice. Let's just look at the technical side here. General requirement of a Rule 36 notice. An expert opinion may only be admitted into evidence on two bases. The first is that there's an agreement that it may be admitted. That you can forget, just ignore that for practical purposes. The second is that the rules of court, especially Rule 36, have been complied with or compliance therewith has been excused by the adversary. Now, there's an important point that follows. The authorities there, don't let that throw you. The reference to case law, don't let that throw you. That's just references to case law. If advocates want to go and look at the cases, those cases or authority for the proposition that's just been made. In other words, when that statement was made above, those two cases support the statement that's just been made. From an expert witness point of view, you don't have to worry about the cases, just worry about the text, okay? So the next paragraph, therefore, in general, before an expert witness may be called, it is necessary to deliver a summary of the witness's opinions and the reasons, therefore, in terms of Rule 36.9 of the Uniform Rules. In other words, when you're preparing your expert reports, you're not just preparing them sort of loosely or on a whim or anything like that. You're preparing your expert reports because the rules of court require you to prepare an expert report and for your legal team to comply with Rule 36.9 of the Uniform Rules of Court. That's what the expert report is there for. And you'll see in a moment what the purpose of Rule 36.9 is, but it is important to then tie this into a point that I made a little while back. That that expert report sets out your evidence and you are restricted to the four corners of that report. So that's why it's important to get it accurate because your report will be scrutinized, but it's also important to bear in mind that it must be comprehensive. You can't easily add to a report. It can be done, but then notice has to be given to the other side. There may have to be an addendum to that. There's a formal process you need to go through. So make sure that you are setting out the whole of your argument leading to your opinion in your report. The purpose of Rule 36.9, the purposes of the sub-rule are to remove the element of surprise from the trial. Remember, I referred to this a little while back. In other words, the other side must be told what you're going to say, and you must also know what the other side has to say. So it cuts both ways. You also need to be aware of what the other experts are going to say. They can't just deviate and start adding in things, which I see happens quite often in trial. Is it the witnesses in a corner, so they just come up with something new? You can't do that. If it's not in the report, it's not before court. Okay? Thus allowing for proper preparation. And there's the thing. When you're dealing with expert witnesses, it's not just lay evidence. You need to have a chance to prepare properly, to consider the different points of view. This is high-level technical evidence. It's amongst the most demanding evidence that you will get in court. And that's for all role players. For you as experts, I can assure you for the advocates can be extremely demanding intellectually, and for the judge to come to the right conclusion. Okay? And to enable the experts to exchange views before giving evidence and thus to reach an agreement on some, if not all, of the issues, thereby limiting the duration of the trial and consequently the cost. So that's where the meeting and the joint minute will come in. But again, even the foundation of the meeting and the joint minute are the expert reports. If you've set out your expert report well and competently, then that stands you in good stead, even against your opposite number in that meeting of experts, and then serves as a very useful way to set out your joint minutes in an appropriate way. So that's those are the purposes of the expert report. Then the expert report they are frequently very involved. The frequently very involved and technical nature of expert evidence requires that the other party should be able to prepare to cross-examine the witness, and if necessary, to allow their own expert witness to prepare in advance to counter such evidence. So this is where it's important that a good legal team works with the expert. So when your advocate is preparing for cross-examination, he or she should include you as an expert in preparing to cross-examine your opposite number. And it is then important for you to be able to explain to your advocate the most important points in simple and effective terms. Remember that there's a lot of technical information that comes through in expert reports. What you want is to be able to sit down with your advocate. I like to start, those that have worked with me will know, I like to start with the conclusion, which is or sometimes called a summary. When I get an expert report, I first can look at is the conclusion. What's the summary? I don't want to read all the rest first because I don't know where they're going. I'll first want to know what they're saying. And if I get 10 expert reports, I'll read the 10 expert reports' conclusions. And if there are 10 on the other side, I'll read those as well. And that then gives me the overall view of the case. And then I start unpicking and I say, okay, this is the conclusion formed by the expert set out in the summary. And for those of you that got the book, you'll see the summary is very, very important, executive summary, etc. Absolutely crucial for these reasons. Most judges will do that. They may have limited time. Remember, the judge is the person deciding this case. Now he or she, for those of you that have been in trial court, that file in most divisions is allocated on the day of the trial. And there's all this technical evidence. Think about it for a minute from the judge's perspective. This is so important. The judge comes into court, he or she knows nothing about the subject. You have had years of training and experience, and you're obviously good at what you do because you've been appointed as an expert in the case. You've also had months, if not years, probably years, sometimes a decade, of dealing with this particular case. So the judge doesn't have any of that either. The judge is coming in stone cold. The most that will happen, normally, the judges differ, but as a rule of thumb, is the judge will have an opportunity to look at the pleadings, which is why I've pointed out the pleadings are very important, and then to look at the summaries of the experts. What's the bottom line? What's this expert saying? What is this case about? You'll see they'll ask advocates will be asked, what is this case about? What are the issues is what the judge is looking for. What's in dispute? And that'll happen in the opening address before evidence is called. Normally the experts aren't there. They may be in the gallery. But that the judge will want to be orientated. So your summary is extremely important for a whole variety of reasons. Okay, if you can set out a good summary that reflects all the key points, so it's comprehensive, but it doesn't waffle, and it sets out the structure of the argument made in your expert report. It's a very important point. Your expert report should not just drift all over the place because you're trying to write 60 pages and charge a big fee. Your expert report should be designed to arrive at a conclusion of an argument. That's your opinion, and that's really what you're being paid for. But then you've got to back that conclusion up with proper reasoning, proper reference to facts, so proper reference to whatever the appropriate medical principles are, textbooks, assessments, other documentary evidence, anything of that nature. You have to back your opinion up with a process of reasoning. That's what's critical and what will determine whether you succeed or not in that particular trial, is whether your reasoning process is correct or not. Okay, and that actually takes us on to the provisions of Rule 36(9)(a) 1 and 2. There was an amendment. For many years, we used to call these A and B notices, 36(9)(a) and B. That's now changed recently. The requirements in terms of Rule 36(9)(a) of calling any person to give evidence as an expert witness are that one, there are various time frames here. I'm not going to take you through those two paragraphs. But what is important on those paragraphs is that there must just be a notice of intention to call the expert. That's the first thing that needs to happen. That's paragraph 1. So you need to tell the other party, we're going to call Joe Bloggs, okay? And then 2, there you'll see has delivered a summary of the expert's opinion and the reasons therefore. Now, that's critical to understand. In other words, what has to happen in order for you to be able to testify? There has to be a notice given in terms of which your legal team has to deliver a summary of the expert's opinion. Exactly what I've just been saying. What is the bottom line? What is your end conclusion? What's the point of your evidence at the end of the day? And the reasons therefore. In other words, what in different language of the expert's argument, the opinion, and then the reasoning process backing up that opinion. Okay, then let's have a look at the expert's summary of his or her opinion and reasons therefore. Never mind the preamble. I just want to take you to Rule 36(9)(a) and take you through the language of this rule and just discuss it for a few minutes. No person shall, save with the leave of the court or the consent of all parties to the suit. Remember, we've already looked at this. It can be done by agreement, what we're going to look at now, which is basically how you get expert evidence into court. So that's a consent of all parties to the suit, because there may be the plaintiff and defendant, there may be 6, 7, 8 parties to a particular suit, okay? But no person shall be entitled to call as a witness any person to give evidence as an expert upon any matter upon which the evidence of expert witnesses may be received unless, all right, so unless there's agreement, which, as I said, for practical purposes, you can disregard that. These are the requirements for expert evidence to be led. 1, where the plaintiff intends to call an expert, the plaintiff shall not more than 30 days after close of pleadings, or where the defendant intends to call the expert, the defendant shall not more than 60 days after close of pleadings have delivered notice of intention to call such expert. And then during those time periods, I'm not going to go into the time periods, but the important point there you'll find at the top of page 171, shall have delivered a summary of the expert's opinion and reasons therefore, provided that the notice and summary shall in any event be delivered before a first case management conference held in terms of Rule 37(a), or is directed by case management judge. Don't worry about the case management aspect. That's not something within your ambit. But I just wanted to show you, it's important to realize this is the exact rule governing expert evidence in the Uniform Rules of Court. Now, you don't have to understand everything about that rule as an expert. Your lawyers will have to. But it is important for you to appreciate the fact that the court is looking for your opinion and reasons therefore. That comes from the rule itself, and that is your job as an expert. And to give a proper opinion backed up by proper reasoning. There are cases, we won't get into it, but the leading cases on how courts assess expert evidence is, in the final analysis, the courts say it's the process of reasoning that the court is going to scrutinize. Okay. And that applies to your evidence in chief, it applies to cross-examination, it applies to questions from the court. And incidentally, it applies to the pre-trial process, your joint minutes and the like as well. Okay. I just want to have a look here at B. The summary of the expert's opinion and reasons therefore referred to in subparagraph A2 shall be compiled by the expert himself or herself. This is a new provision in the rules that until a few years ago wasn't there. There's an important case which is actually included in the expert witness guide, in terms of which the Supreme Court of Appeal criticized the way that expert reports were being compiled. And there was then an amendment to the Uniform Rules of Court to introduce these provisions. But in any event, so the summary of the expert's opinion and reasons, therefore, shall be compiled by the expert himself or herself and shall contain a statement by the expert confirming that the report is in the expert's own words for the assistance of the court and a statement of truth. That's the declaration that you now need to make on your expert reports. And there it is. That's in the Uniform Rules of Court. That has to be included in your report. Some attorneys are better than others at this, but the rules of court require that the expert must set out 1, 2, and 3. So very important. All right, just the next paragraph. In respect of the amendments introduced by the new Rule 9b, the sub-rule now expressly requires a summary of the expert's opinion and reasons, therefore, to be compiled by the expert himself or herself. I just want to go to the next paragraph, towards the end of the next paragraph. Previously, the summary and reasons, therefore, were frequently drafted by counsel who would be responsible for running the trial. That was quite a challenging thing for counsel to draft when you had to set out our reasoning and the opinion, because you needed to understand exactly what the expert was saying. It was, I think, a very good process for counsel to have to go through that and understand that reasoning process, because that allowed you to get a firm grip of the evidence. These days, it's supposed to be done by the expert. There is a certain amount of assistance which legal representatives should provide to the expert, but they cannot replace the expert providing that summary and reasons therefore by the expert. They can give some indication of how it should be done and what issues are in dispute and the like, but they can't do the drafting for the expert. Now, the proper drafting of the summary of the expert's opinion and reasons requires a clear understanding of the issues in dispute between the parties. You must know what's in dispute. And remember, this can change over time. So when you draft your report, you should know, for instance, whether general damages are in dispute, whether negligence has been conceded. You should have an idea, and in fact, you should have a very clear idea of what is in dispute between the parties. In other words, what are you being asked to comment on? Okay, 2, the opinions of the expert in respect of whom the summary is being provided. Okay, and 3, a logical and comprehensive statement of the reasons for the opinion. Okay, so 2 and 3, what I mean by that is that you must be clear on what your opinion is. Have a firm view of that. Don't be uncertain and don't hedge your bets. You have to give a clear opinion on the issues in dispute. And there may be more than one issue. Be aware of that. And then a logical and comprehensive statement of the reasons for the opinion. That I've been through that this evening. That's the reasoning process that you must be familiar with. Again, we do in the expert report section of the book. For those of you that want to, can go and have a look at that. There are some common pitfalls that occur. Just be aware of those pitfalls and avoid them. The summary and reasons should be crisply stated yet comprehensive. Avoid unnecessary prolixity and waffle. In other words, don't waffle. And must fully set out all lines of argument relevant to the issues in dispute which fall within the province of the expert witness. What that means is that the summary and reasons, remember, so you've got your expert report. At the end of the day, the summary is your opinion and reasons must be clearly stated, okay? But they must be comprehensive. So don't, by making them crisp and clear, miss out on important information. You must get, where I say that fully set out all lines of argument must be dealt with in your summary, in your expert report. But you must avoid unnecessary prolixity and waffle. What that is, you get this padding. Very often it's cut and paste stuff. And it's not advancing that argument at all. It's just there to make the report look fancy. Now it's 65 pages instead of 5. That's supposed to impress you. Okay, what's impressive is the reasoning process. And I can assure you that when you put under pressure, those 65 pages are not going to help you. They're going to get in your way because you're not going to have a clear understanding of what it is that you're saying. Now, I'm not suggesting that your expert reports should be 5 pages long. What I am saying to you is that you need to be comprehensive, but you need to be clear on your lines of reasoning, and all your lines of reasoning must be there. So your report should flow in a fairly logical and comprehensive way. Okay. All right. I'm not going to take you through the rest of these contents because I think I've dealt with the main points on the expert report. Even the declaration, which is at page 75. I was going to quickly take you to the declaration. Let's have a quick look at that because that's important. So based on the rules of court, here is a standard declaration which you can use. This is, as you'll have seen from this is modeled very closely on the Uniform Rules of Court, and so that shouldn't attract any problems. And there's a standard declaration of pages 175 to 176. Okay, let's see how we're doing for time. We're doing fine for time. Okay, can I just then, before the next topic that I want to deal with is the meeting of experts. But just before I move on to that, I do have two questions. And so let me just quickly get through this. So Johan, thanks for your question. Johan Bernardi asks, what do we do if you are not available on a trial date? For instance, you planned a vacation. Johan, you may have to cancel that vacation, I'm afraid. You could try to arrange to testify by video evidence if you've got an accommodating judge. And you can certainly try to arrange with your legal team that they work around your personal challenge. But at the end of the day, you're in the High Court, and unless some accommodation can be made, you would be expected to be there. Now, in most cases, we can accommodate you. I mean, I know I do. I try. You get these sorts of things come up all the time, and we really do try to accommodate witnesses, especially if it's an overseas holiday. You don't say that was in fact the problem. If you're just sitting at home, doing gardening or something, then maybe you should be at court. But your counsel will obviously try to assist you within limits. But you must remember that trial date is absolutely precious. We wait so long for trial dates, and there's so much tied up with getting that trial run properly, that those sorts of inconveniences, I'm afraid, come a very distant second to the importance of running that trial properly. Okay, Leo, we've got one from Pam Pillay. Thanks, Pam. Good evening. I presume that knowing the issues regarding liability and quantum is the advocate's role, especially in defense cases, or does the expert witness get factored in? All right, so it's a little bit of I think this touches on the point of teamwork. There certainly are aspects of the case where it's really the advocate's territory, and he or she will then, whether that's within their field of expertise. It's not necessary for the expert to understand every last detail. However, there is a good amount of scope for the advocates to interact with the experts regarding, and for the attorneys to interact with the experts regarding the issues. Now, you've defined the issues as liability and quantum, and that obviously is the sort of the main division, if you like. The standard thing that comes up is either you're there for liability or you're there for quantum. But there are many sort of sub-issues that arise within that. So, for instance, on liability, the question of whether negligence is admitted or not may be an issue, or the question of causation, which comes up often, particularly in medical malpractice cases, but even in RAF matters, causation does certainly come up. And then, of course, on the quantum side, whether it's patrimonial or non-patrimonial loss, whether it's past loss, future loss, all of those subcategories of the various heads, or what we call heads of damages, need to be understood. And then even within that, it's important to understand in a bit more detail, well, what is it that under, say, future loss, where is the real disagreement? The experts should be familiar with what the other expert is saying if they have filed a report before they write their own report. And so it's good practice. If you know, the foundation of these things ultimately is a good working relationship with your attorneys and your advocates. But it is very good practice to be instructed with any expert report that is relevant to your report before you go and even do your assessment. So different firms of attorneys are there are different levels of competence and all that. But it's that's important that you also, when you get to the trial work and appearance at court, very important that you spend at least a few minutes with your advocate. Sometimes there's a lot going on in the trial. But before you testify, your advocate should give you an update on what's happened in that trial. Now, the advocate's in charge of the process. Different advocates have different styles and different requirements. But if you get a chance, it is a very good idea to ask that advocate what has happened in the trial. Are the issues that were originally in dispute still in dispute? And another aspect of that is, just in summary, what has happened which would be relevant to my evidence. A good advocate will be able to bring you up to date quite quickly. They should be well aware of developments and what's happening and how that's affecting the issues. So that I think is important. All right. All right, we've got a question on qualifying fees. That I'm not going to get into that. That's a costs and charging aspect. But I think we will do some work on costs and charging and all that sort of thing. So just keep an eye out on the South African Medico Legal Reports. We will get into that in more detail, because there's quite a lot on that, and that's out of the scope of today's presentation. Okay, let's have a look then at if we can go to page 180. I beg your pardon, page 181. Apologies. Let's have a look at the meeting of experts. I see we're about 7:30, so we'll get through. We'll spend from now until around just before 8, quarter to 8, 10 to 8. We'll spend on the trial preparation stage, and then we'll spend the last hour. We will deal with the trial stage itself. Okay. So the meeting of experts, the uniform rules of court require that a joint minute of experts relating to the same area of expertise must be filed within 20 days of the date of the last filing of the expert reports. It is desirable for efficient case management that the experts should meet with a view to reaching sensible agreement on as much as possible, so that the expert testimony can be confined to matters truly in dispute. This is the purpose of the joint meeting. Let's have a look at the rationale for joint meeting of experts, and then I'll comment. A fundamental feature of case management in South Africa and abroad is that litigants are required to reach agreement on as many matters as possible, so as to limit the issues to be tried. Where the matters in question fall within the realm of the experts rather than lay witnesses, it is entirely appropriate to insist that experts in like disciplines meet and sign joint minutes. The principles developed by the High Court spell out in detail the duties to which expert witnesses are subject, including, where so directed, to a duty to meet and, where possible, reach agreement with the expert on the other side. So it's a requirement that you meet with the expert on the other side. The reason is to narrow the issues. Okay, it's not to try and settle the case. It's to try and get together with your opposite number and work out what is really in dispute here. And I say that quite lightly, but sometimes that can be a challenging process. And I see so many joint minutes where that most fundamental purpose of the meeting of experts is not fulfilled. You should identify in your JMs, in your joint minutes, clearly what has been agreed and what remains in dispute. And why is that? Again, if we just zoom out and we look at the whole process, remember that your advocate needs to know and the judge needs to know, what are we here to determine? so that you can cut out unnecessary court time and unnecessary preparation. It's all very expensive. So if you can focus your efforts and then the efforts of your advocate and then the judge's mind on the issues that are truly in dispute, that is the purpose of the joint meeting. Okay. It's also useful because if you are able to yourself really figure out in detail what is really in dispute between the parties, and it may be the conclusion, for instance, on future meds or loss of earnings or some broad subject, but then there may be underneath that, there'll probably be one or two issues that are specifically in dispute as to why that head of damage is not common cause, not agreed between the parties. And it is important to get sort of right into the detail of what it is that's being disputed in this particular matter. Okay. And then I'm just going to have a look briefly at conducting joint meetings, and then we'll get onto some tips about joint meetings of experts. This is from the Supreme Court of Appeal Authority of AM and another versus MEC for Health Western Cape. That's an important judgment. That's the judgment that led to the change in the rules. But the following comment is one of a number of important comments in that judgment. Pre-trial meetings should not be seen as nothing more than a necessary formality in order to secure a trial date. They should not be conducted telephonically or by way of correspondence, without any engagement on the nature of the disputes between the parties or any real endeavor to clarify and limit the issues. So I've made that point, but actually, don't worry about the fact that I said it. It's the Supreme Court of Appeal that has said that, and the judges and advocates will take that very seriously. And those are your duties are set out by a very senior court. And that is to try to identify and clarify and limit the issues. Okay, I'm going to just go through now some tips for experts, which we've set out. These tips for experts are based on the case law, but it's also based on experience and commentaries by various commentators, but it's a distillation of those sources really. So first, with your joint meeting of experts, 1, make sure that the documents with which you've been provided are complete and up to date. The case will normally have been going for a long time, with many reports from both sides, many of which may have been filed after your report. You should, at a minimum, have a copy of the latest versions of all expert reports relevant to your report. Okay, this is specifically now at the joint meeting stage, but it obviously will apply later at court as well. All right, make sure you've got the proper documents. 2, you should ask for an updated index to the bundle of expert reports in order to prepare for the meeting, depending on your level of efficiency of your attorney. But in one form or another, whether there's an updated index to if they've already prepared a bundle or not, depends on the style of that attorney. But I think the underlying point is you should just ask for a list of what reports are relevant to your report or to the joint meeting which you're about to have, to make sure that you've got the latest version of those reports and that you've got them all so that you can consider that. Okay. And then 3, prepare for the meeting. I mean, it sounds so obvious, but it is so important. Make sure that you've read the relevant documents. This may sound obvious, but it's surprising how often joint meetings are held without this having been done. You'll probably not have looked at the case for some time. Remind yourself of the facts and issues. In other words, go through your own work as well. Just spend a bit of time, an hour, half an hour to an hour, whatever it takes to familiarize yourself and prepare properly for that meeting. And then also really part of the preparation, consider the agenda for the meeting. This is very important, particularly, if you're going to be having a joint meeting, there are obviously issues in dispute, but sometimes those issues are not all that complex. Sometimes they're tremendously complex. But whatever the level of complexity, consider the agenda, decide what you regard the issues to be, and your approach to agreeing on each issue. So try and identify those issues, and then what's your position on each issue. And contact your attorney to discuss any queries ahead of the meeting. If there's anything that you need to find out, get hold of your attorney. It goes back to that point I made earlier. that working relationship in practice is so important. You must be able to pick up the phone and just have a chat to your attorney and say, look, I just don't understand. There seems to be a missing document, or has there been some movement on this particular aspect of the case? Or, I wasn't too sure about that collateral witness. Are there other collaterals which we could look at? Whatever the situation is. Then 5, agree with the other expert that enough time will be allocated for a proper discussion with plenty of time for the meeting. Do not regard the meeting as a mere formality. You saw that the SCA actually says you should not be having telephonic pre-trial joint meetings. Now, I know that's more, I know the pressures of practice and what actually happens is that these things are done informally, but be aware that the Supreme Court of Appeal has said that should not happen, that meeting should be in person. And I'll just leave that comment there. But importantly, do not regard the meeting as a mere formality. You need to go through the issues and canvass them with the other side. 6, don't try to settle the case in the meeting. It's not the job of the expert to settle the matter. The role of the expert is to summarize your positions on the key issues. That's both of you. Summarize your positions on the key issues, including indicating where you agree or where there's only narrow disagreement, together with your reasons. Okay, so that's your role. It's surprising how often it happens that expert witnesses somehow take on this duty of trying to settle a matter and get into long discussions about how the matter should be settled or that particular aspect. That's not the role of the expert. Your role is, again, you've worked out your position before the meeting. Go into the meeting, summarize your position on the key issues, get your opposite numbers' position on the key issues, and then set out whether you agree or whether there's narrow disagreement, and then set out the respective reasons. Sometimes I see joint minutes coming through as on a sort of table form. I find that very helpful, that the issues are then identified and the respective positions of the two experts are set out in a sort of like an Excel spreadsheet. I find that very, very helpful. 7, if you change your opinion from that set out in your report, you must explain why and be prepared to fully motivate the change in view through a process of logical reasoning. Okay, now this goes to something that has been like something of a theme through this evening's presentation. It's very important that you get your thinking right in your report. However, don't sort of bombastically stick to a particular view. It may well be that during the course of preparation for trial, even your opposite expert might think of something that you didn't think of, but that's perfectly valid. Or there could be facts that come to light which you weren't aware of previously. And now, but it changes the complexion of the case, and in fact changes your opinion. It is very important that change of opinion is identified early. And if it's being done before the meeting of experts and then before the JM is signed, it's tremendously important, because the one thing that as an advocate I do not want, and no advocate wants this, is that the expert changes their opinion in the witness box. That's what you don't want, because that can cost you the whole case with hundreds of thousands of rands of costs, implications, and millions of rands of implications for your client, one way or the other. It is the one thing that you really do not want from your expert. So expert witnesses should take pains to ensure that when they give an opinion to counsel, that opinion is something that they can back up in the witness box. And part of that process is being intellectually honest and flexible enough to identify when there's a problem, when there's a need for a change of view because something legitimate is being raised. And it would be an error to simply overlook that and to be dogmatic in your approach and not take that valid point on board and then advise your legal team accordingly, I would say advise them in that situation, advise your legal team, get hold of your attorney and raise with them. There is a problem here. This other expert has raised something that may be valid, looks valid to you. This is why. You take your attorney through that, and you must clearly articulate what your position is. And you've got to have a bit of courage as an expert. You've got to have the courage to tell your attorney that at that stage. Do not leave it so that it comes out in the witness box. Okay. But if you do change your opinion from that set out in your report, just be aware of this as well. It's not actually ideal if you're changing your opinion. Ideally, you've got an opinion, you stick to it, you go through the whole process, and that's fine. Where it's valid and necessary for you to change your opinion, you should go through a process. In other words, you should, again, it comes down to being able to rationally and logically explain why you've now got a change of opinion. That's important because this can affect your credibility as an expert. If you don't properly motivate your change of opinion, I can tell you a cross-examiner is going to home in on that and is going to start undermining your evidence because now you had this opinion, now you've got that opinion. Why the change? And questions based on that can be devastating. So make sure you preempt that and you protect yourself by setting out the reasons for your change. 8, where you disagree with the other expert, fully state the issues you disagree on with reference to any disagreement on the facts and reasoning, okay? Do not simply state your opinion or the fact that you disagree. That's unhelpful. Don't just say, well, we disagree on point 1, 2, 3, and 4. How does that help? Unless you agree on an issue, you must give reasons for your views. So go through, identify what are the facts that you disagree on. Now, it may well be, and often is, that you are given certain assumptions that you have to make. In other words, you are told by your instructing attorney that these are the circumstances, for instance, an employment history. Although that is checked to a certain extent, there will be personal information that you are sort of asked to assume. And it may be that, those facts are an issue. So the other side has a different view. And in fact, the trial might turn on which of those two versions is true. And it may be necessary for the judge to hear these 2 points of view and see cross-examination and everything before the judge decides one way or the other. That often happens with expert reports. It's actually not that often that you get sort of genuine disagreements on the professional points. In other words, on the more technical aspect of that particular expert. Normally, the disagreements come about because there's some sort of the assumptions or the premises on which the expert's reports are based are different because they're different versions before court. That's normally what's happening. So it's important for you to, however, to identify where those differences are. You're basing your opinion on these facts. He's basing or she's basing their opinion on those facts, and that's where the difference, and therefore you come to different conclusions. Okay. 9, make sure that any important points are recorded and agreed with the other expert in the meeting. Remember that you ultimately may not give oral evidence, and the record in your report and minute will then stand as the record of your views. You see, what happens during the settlement process is that, as you know, most matters settle. So there's a good chance you're not going to give oral evidence. But where there are important points that come up relating to your particular evidence, you should make a note of that and keep that and incorporate that in the minute. And the reason for that is that the reason which we've discussed, but it's important for your advocate to have an understanding of what is going on in some detail as regarding the difference between the two experts. Because where you have cases involving expert evidence, the fact that you've got experts is almost without exception a very strong indication of where this matter is going to be resolved, which way it's going to go. In other words, the way that the expert evidence is resolved by the judge will determine the outcome of the case. That, and then normally the plaintiff's evidence and that underlying it. But the expert evidence is very important. It's very important that the advocate is able to understand the details of where you're coming from and the disputes so that the advocate can properly steer the settlement process, even if you never get into the witness box. Then 10, and it sounds obvious, but gee, I've seen this happening. Never sign something you don't agree with. Just please take these minutes seriously. We'll look now briefly at why this is important. The importance of these joint minutes. Never sign something you don't agree with. Check the details of the minute carefully. Those details can inform whether you win or lose that case. And you as an expert do not want to be the one responsible for losing that case, I can assure you. Err on the side of pedantry rather than inaccuracy. Rather be too meticulous than too loose. The written word is extremely powerful in litigation, and you must be entirely satisfied with anything you sign. Please, point 10 is very, very important. Be pedantic about your joint minutes. Make sure that it's accurate. Now, I just want to take you to, just to develop that point, I want to take you to page 187. And right at the bottom of the page, status of agreement reached in meeting of experts. Where agreement is reached at a joint meeting of experts, which is recorded in a joint minute, those agreements bind both litigants to the extent of such agreements. In other words, when you agree something in a joint minute, the parties are bound by that agreement. It cannot then be raised in the trial unless certain steps are taken to repudiate that minute, which is a formal process, due notice needs to be given, etc. So when you agree something with your opposite number, you are in fact taking that particular issue out of the list of issues that are now in dispute and which can even be debated. It's as if those points have now been proven at trial. That is the effect of agreement in a joint minute. Just moving to page 180, sorry, that was, I beg your pardon, I just want to, excuse me for scrolling like this, I just want to get the paragraph numbering. 4.2.3, conducting joint minutes, just for those working with different versions. Sorry to make your eyes go squiff here with the scrolling, but anyway. All right, so we're at page 188. So where experts are asked or are required to supply facts, either from their own investigations or from their own research, and an agreement is reached with the other party's experts about such facts. This is now investigation of facts. Such an agreement on the facts enjoys the same de facto status as facts that are common cause on the pleadings, facts agreed in a pretrial conference, or in an exchange of admissions. I'll explain that to you in a moment. An expert may not be cross-examined on an agreed position of fact or opinion unless before the trial begins the opinion of a party's own expert has been formally repudiated. Where a joint minute has been filed, it will limit the issues on which evidence is needed. Okay, so let's take those paragraphs now just to unpack this. So where I've given the general point that where you agree something in a joint minute, it's cast in concrete. The advocate can't do anything about that. And even the judge, they can't do that. Once it's agreed in a joint minute, it's agreed and it's proven. That's the status of a joint minute. Now, in particular, where experts are asked or are required to supply facts, either from their own investigations or from their research, and an agreement is reached with the other party's experts about such facts. This is one example of the broader point about joint minutes. Such an agreement on the facts enjoys the same de facto status as facts that are common cause on the pleadings. Now, I just want to explain that. Remember I said to you that the pleading stage is the summons and then the plea. So the formal documentation. One of the very important functions of pleadings is that when the plaintiff sets out his or her case, there's a response. And what in the plea, it's very important that, and necessary, that the advocate preparing the plea must admit or deny or not admit every factual allegation in the summons. In other words, what happens is that the defendant then formalizes its position on the facts. And that then becomes, again, cast in concrete. The parties can't move. Once they've made that admission, it's very difficult to then undo that admission. Can be done, but it really is difficult and causes problems. And the point that's being made in this paragraph is that when in a joint minute, facts are signed as agreed, it is as if those facts are contained in those formal court documents, the particulars of claim and plea, and are therefore common cause between the parties. In other words, they can't be debated at the trial anymore. It is a profound implication to agree those facts. And that applies also to a pretrial conference. That is something that a pretrial conference in the sense that the legal representatives attend, or in the exchange of admissions. Okay. And that's why an expert witness then can't even be cross-examined on an agreed position of fact or opinion, unless, and now this is where, remember I said that you have to give notice. You have to give notice that you're repudiating that particular position. There's a whole process that has to then be followed with cost implications and with complications. So be very careful about signing your joint minute. Okay, let's have a look I'm just going to go to page 190. The form and content of the joint minute, and then we'll finish off on the trial preparation stage, and then we'll take a short break, and then we'll get into the trial stage itself. Just to go through those 5 points on the form and content of the joint minute. There's no set format for either the meeting or the minute. Experts, lawyers, and the court can all contribute to a format that suits the nature of the case and the expert evidence being presented. A useful starting point, however, is for the joint minute to begin with the proper identification of the issues or questions which the experts are asked to answer or address. So there we have that again. Remember, just make sure that you're clear with your attorney. What are the issues? Or putting it slightly less formally, what questions do you want me to answer? What questions must be dealt with by me at this joint minute, at this joint meeting? Insofar as the structure of the joint minute itself is concerned, a common format is to use an annexure with columns and rows. That's what I referred to a few minutes ago. The following columns appear. So this is how that would look. As I've said, I've found this particularly useful. I think it's useful for the experts to do it this way as well, because it focuses your minds. You know, it avoids this kind of loose thinking where you don't really know what the issues are. It forces you to identify the issues and state your positions on those issues, and to get your opponent to do that. So very useful exercise in my view. Number one, a number tracking the questions or issues or sub-questions or sub-issues within a list of issues. So just numbers down sort of one, what do they call it, one column. But with those numbers correlating to issues. And then 2, a statement of the question or issue to be answered. For example, is it agreed that the defendant performed X procedure on the plaintiff? So we're in a negligence claim. It may be, the allegation was that there was a negligently performed hysterectomy, total abdominal hysterectomy, for instance. The question there would be, is it agreed that the defendant performed a total abdominal hysterectomy on the plaintiff? And you may be surprised. The answer may be no, it's not. It's agreed there was a hysterectomy, but it was a subtotal abdominal hysterectomy. So you see, by asking these questions and being precise, it's amazing what comes up. So that's the first thing, is just a statement of the question or issue. Then secondly, agreed issues. So now, do you agree? We agree that the defendant performed a total abdominal hysterectomy on the plaintiff. 4, areas of dispute beginning with the plaintiff's expert's views. For example, the plaintiff's expert does not agree that a total abdominal hysterectomy was reasonably indicated in the circumstances of the case. So now you're getting to a slightly different issue. So firstly, was that procedure performed? And then areas of dispute. Was it necessary to perform the operation? One expert says yes, the other expert says no. That disagreement should then be identified and full reasons should then be set out. When I say full reasons, obviously in summary form, but you don't go for pages and pages, but set out all the key reasons should be included. Don't miss a reason because it just opens up the possibility of complications, either in cross-examination or by some allegation that this is beyond the scope of the inquiry. So please be thorough in your setting out your reasons as well. And that's what I mean by full reasons. And then 5, defendant's expert's opinion on areas of disagreement. For example, the defendant's expert's view is that X procedure was the total abdominal hysterectomy, and this example was reasonably indicated in the circumstances of the case. And then full reasons are then set out. So you've got your issue, you've got your plaintiff's expert's view and reasons, and the defendant's expert's view and reasons. If there are more than 2 parties, the number of columns can be increased. Let's not worry too much about that. And then don't worry about the remaining of that, or the next paragraph. But then let's look at the following one. Experts should give their views in a concise and point-form manner to be of real assistance. The structure should allow the legal representatives, other experts, or the judge to go to the expert reports or minutes for elaboration if they wish to read more. It is therefore important for the experts to cross-reference their points to their reports, the reports of the other experts, or the published literature on the subject. It is very unhelpful for an expert to make a point and leave the reader to trawl through the reports or professional literature for elaboration. That is an important practical point. Where you're making your points, please just put in brackets at the end, see paragraphs 5.3 to 5.6 of my expert report dated 23rd of May 2025. Okay, so that it's then, because what will happen is that certain issues will come to the fore in the trial. And it may be issue number 3 that's decisive. And you want your advocate and the judge and the other side to be able to get quickly to that's all right, that's what your view is. I want to understand that a bit more. Okay, I go to paragraph 5.3 and I read that. And I read through to paragraph 5.6. Right, got it. Now I read those paragraphs and I understand what your view is on that particular topic. Now I want to see what your opponent says and a similar process. Okay, then I deal with some exceptions, which I'm not going to go through now. And then there's a joint minute declaration, which is recommended in the textbook. You'll see that still under paragraph 4.2.3 and at page 193. All right, it's 5 to 8. Let's take another 10-minute break, and we can resume at 8:05. I'll do the same thing. I'll put my video on when I'm ready to.
Ndilibele ukuthi uzukho babuze phaa kulaa ndawo ezaa ndawo yegesi phaa ye-19 babi nabo number 48.
Ababikho baninzi, it's on import, but kuyafana no-19 aba, o-19 ababadingayo baninzi. That's why abantu kuyafana most of the time ko-19 bengekho bathi bazawuthi ibharishi. Besoloko ikhona inintsi.
All right, I'll just come back a minute or two early. I'm just going to allow people to get back to their desks. But just in this time, I don't want to prejudice the discussion on cross-examination and evidence in chief. So I'm just going to quickly deal with one or two questions that have come up. LZ Leroux asks the following regarding a case where a clinical psychologist was asked to report a case on behalf of a client and is asked to appear in court. Does she appear as an expert witness or lay witness? If an expert witness, how does the role differ from other types of cases like RAF, etc.? Just not too sure what the facts are there in a criminal case where a clinical psychologist had to report a case on behalf of a client and is called to appear in court. The question there is this person being called as a lay witness or as an expert? If you're being asked to give a professional opinion on a topic relating to that matter, then you're being called as an expert. However, it's possible, I can't tell from your question, but it's possible that the person, although he or she is a clinical psychologist, is actually being called to give purely factual evidence. That then would not be expert evidence as we understand it. And then that would simply be, you happen to be a clinical psychologist, but you're aware of certain facts. The difference is whether you're being asked to give an opinion. That's the important thing. Or are you just restricted to the facts? Because the essence of expert evidence is this. You are allowed to give an opinion as an expert. You are not allowed to give an opinion as a lay person. That's one of the standard rules of evidence. The courts are not interested in the opinions of witnesses generally. It's the court's opinion that matters. However, where a particular person has an expertise that will be helpful to the court, they will allow that person to testify subject to various stringent conditions, which we've been through this evening. Okay? Then please clarify my understanding. This is the second question. Now this is from Julia Buchanan. This is quite an important question. Please clarify my understanding is that a joint minute is a joint minute, i.e. each party has equal weight regarding content, layout, and flow, etc. of the JM. More often than not, I think it is the plaintiff expert that might start the process and do an initial draft, but defendant expert surely has equal weight regarding fine-tuning of content, layout, argument, etc., or the other way around if relevant. Can sometimes get heated. Please clarify. Yes, absolutely right. It's a joint minute. So it belongs to both parties. Just as far as the style and layout is concerned, it is so that normally in practice, the plaintiff's expert sort of takes the lead. What we say as lawyers, plaintiff is dominus litis, and that, in other words, sort of in charge of the way that in control, not charge, in control of the case. And so it does in practice happen that way. But, you should try to find common ground. And then if you can't agree on anything, including the layout, that's fine. Then stand your ground. This is your position. And you can then set out that joint minute that expert A records the following and expert B records the following. And you should then be allowed to set out your own style and annex and attach it as an annexure, something along those lines. So as experts, even if you can't agree, you must agree to disagree and find a way to accommodate both experts. As an expert, you say it gets heated sometimes. I can imagine it does. You need to learn how to stand your ground, obviously, but do it in a way where, if possible, you can do it mutually. If you disagree, identify the areas in which you disagree and deal with it. The other question, can the joint meeting be on Zoom, Teams, etc.? The Supreme Court of Appeal Authority is silent on that. It just frowns upon these telephonic pre-trials. But if you look at the language and the real point being made there by, I think it was Wallace's judgment, in fact, at that point, by Judge Wallace, is that it was, the point was that you needed to apply your minds properly. And what they were frowning upon is just a sort of perfunctory formality of a joint meeting of experts. So what the courts are looking for is to apply your minds. They do specifically say don't do it telephonically. They don't mention Zoom meetings. I just want to be a little bit careful. But in my experience, Zoom meetings have been absolutely fine. I've never had any problems with that with the judges. If anybody has had a different experience, please let me know. But ultimately, I would defer to your legal team in a specific case to check, is it okay if I do this by Zoom? Just ask the question and get your legal team to cover, and then you're in the clear. Okay. Thank you. Thank you, Alzette. I'm glad I was helpful. Then lastly is another question. If the parties have received the joint minute containing statements of both agreement and disagreement, can they reserve the right to amend these views without repudiation of the agreements contained therein? No. That is not going to be. You have to commit yourself. Once you've committed yourself in a joint minute, that's a commitment. The process itself sets out, and the authorities set out what needs to happen. I haven't been through that in detail. It isn't a textbook, but there has to, for instance, be proper warning to the other side. There's been a number of authorities in point. You cannot just change your position as recorded in the joint minute without giving the other party I think it's a fair chance, is a fair notice, I think is the expression used. I haven't read those judgments for a while, but you have to, in essence, give the other side a reasonable chance to then absorb your new position, go away, consult, consider their position, and if necessary, amend their position, file an addendum or some sort of alteration to their expert reports. There's quite a long process. It's not just there for the changing, and you can't simply reserve that right. That's not going to get you around that. That right to change is built into the process, but within those particular structures. Okay. All right. I think that disposes of those questions. Right. Now, let's get on to the trial itself. So the trial stage. Now, just before we dive into the trial stage itself, look, most matters settle. But there are two reasons why it's good to know about the trial stage. Firstly, you may well be called as a witness in any matter in which you file an expert report. You may well be called one day as a witness. So that's number one. Number two, it is useful to understand the workings of the trial stage, even just in a sort of theoretical way, or that I'm telling you secondhand about it, because it actually helps you in drafting your reports and understanding the role that you're playing, even if the matter doesn't go to trial. Because it's always this sort of looming threat of the trial that focuses the parties' minds and gets them ultimately to settle all these cases. They wouldn't settle most matters, many matters wouldn't settle unless there was the pressure of a trial, or in my experience has been the pressure of some formal hearing, such as a mediation. In my experience, has had a salutary effect on getting the parties to focus on the matter and to come up with some sort of settlement, okay? But certainly a trial has more menace and more weight, okay? So a trial definitely gets parties to focus their minds, and what happens in the trial also affects how you should set out your report, how you should prepare your JMs, how to deal with your meetings with your opposite number. Okay, so let's firstly, and this is, when you get into a trial, I can tell you as an advocate, this is a very important practical point. Witnesses, and by extension, expert witnesses, should understand that there are different types of questions that advocates are allowed to ask. You cannot just ask questions in any way you like. Okay. Now, I've already broken down roughly the process of when an expert witness or any witness gives evidence, that there's a three-stage process to that evidence. The first stage is called evidence in chief. During that stage, the advocate will lead the witness. Very important, the advocate will lead the witness through the witness's evidence. When you are an expert, what the advocate, we'll look at this in a bit more detail, but in summary, the advocate will then take you through your expert report, is really what it boils down to, and will certainly take you through your opinions and the reasons therefore. All right, so that's your evidence in chief, the first stage of giving evidence. Then you get into the dreaded cross-examination, where the other side has a go at you, okay? Some people do it nicely, some people do it nastily, some people a lot of pressure, some people a little bit of pressure. But the process is specifically designed to pressure test your reasoning process. That's why it's called a trial. A trial is an ordeal. Okay? It's not meant to be easy. It's not meant to be pleasant. It's meant to wring the truth out of this dispute that these people are having. That's the purpose of the trial. As I said, it's very formal. In fact, it's actually at times quite ritualistic. There's certain things, the right thing to say and the wrong thing to say and the right way to say it, and there are formalities that one goes through that one has to observe, the way you dress, the way you speak, the way you present yourself. But all of that builds the pressure of the trial. And at the end of the day, cross-examination is designed to test your reasoning process. And we will go through in a moment the 5 key areas that are tested. But for now, what you need to understand is that there are different ways that advocates can ask questions depending on whether they're leading or whether they're cross-examining. And then remember, there's the third phase, which is when your advocate gets to try to put Humpty Dumpty together again. That's re-examination. Okay, which is at the end, the same rules apply. When your friendly advocate is leading you, they cannot put words in your mouth. So they lead you through your evidence, but they are not allowed to give evidence for you. Okay, so let's have a look at that. When giving evidence in chief, that's the first phase. Witnesses, as a general rule, may not be asked leading questions. So it sounds a bit strange, right? They're leading you, but they can't ask leading questions. And that is because of the point that they're leading you through your evidence. They're not giving evidence for you. That is the advocate. So he or she must get you to give your evidence without putting words in your mouth. And the rule that applies there is, in other words, counsel may not ask questions which are suggestive of yes or no answers on disputed issues. Where things are common cause, he can just get through it and say, it's common cause that the plaintiff underwent a subtotal abdominal hysterectomy on the 13th of May, 2025. Not so. And you can say yes, because it's agreed. It's not in dispute. But when it's in dispute, the advocate cannot do that. That would be putting words in your mouth. So the advocate cannot just say to you, the plaintiff suffered loss of earnings in the amount of 800,000 Rand. Is that correct? And you just nod and say yes. That's not getting your evidence. That's the advocate giving evidence. So I use an example. For example, counsel, when leading the expert witness's evidence, cannot ask, doctor, in your opinion, was the injury caused by the surgery? Now, if that's in dispute, that the injury was caused by surgery, you can't ask that question. That's a leading question because it suggests a yes or no answer. All right, so that question would not be allowed. A better question, just off the top of my head, would be that the way that you would have to ask that is, doctor, what was the cause of the injury suffered by the plaintiff? Now, you notice that's a totally different way of asking that question. What was the cause? In other words, it's an open-ended question. Now the witness must answer that question. Well, in my opinion, the injury was caused by the surgery which occurred on such and such a day. Would you care to elaborate on that? Some follow-up question along those lines would not be a leading question and would be perfectly permissible. Okay. So this rule applies to any issue which is in dispute between the parties. Where issues are not in dispute, counsel may ask leading questions during evidence in chief. Okay. So it should therefore be noted that only open-ended questions may be asked when leading a witness on issues which are in dispute. Now, this is important when counsel leads the evidence of an expert witness, because counsel often cannot suggest the answer to the question. This calls for a certain amount of cooperation between counsel and the expert witness, where the expert witness must follow what counsel is trying to elicit from the expert witness. There are occasions where witnesses forget these principles and expect counsel to put their questions more directly than they are allowed. This cannot be done, and the expert witness should try to listen carefully to the questions being asked and provide accurate answers. In other words, what happens is you get into a situation where counsel is trying to get something from the witness, and the witness is sort of wanting a more direct question, but counsel can't ask that. So it's important to understand what it is that you're being asked to testify on, and when you're in the witness box, be aware that advocate's not being stupid. That he's just, why can't he just ask me directly? It's that he can't ask you directly, and you are expected to work out what it is that he's wanting the answer to be and to cooperate with counsel. You will find, particularly with more junior advocates, this can be quite a challenging process. They can get themselves horribly in hot water asking leading questions, the judge getting a bit tetchy because they're asking leading questions, and they can get terribly flustered and then ask more leading questions. So be aware of that dynamic. Okay, then you've got your evidence in chief, which is basically that's your first stage. Just regarding preparation for evidence in chief, the evidence in chief should have been prepared with counsel before the witness enters the witness box. The facts relied on by an expert should be established by asking the witness in evidence in chief what those facts are. For the reason I've just set out, you must have been through that with your advocate so that you both know what he's going to deal with or she's going to deal with. All key aspects of the expert witness's evidence should have been canvassed and counsel instructed on those aspects. I just want to move down because I need to move on to cross-examination. But let's have a look at I just want to take you through, this is what we're taught as advocates to lead an expert witness through this. It's what I apply in my practice, and it's a very effective way. It's not to say that every advocate will follow this, but it is useful for you to be aware that this is the sort of the standard approach to leading an expert witness. The first stage deals with the establishment of the expert witness's expertise. Okay, so why are you an expert? And in particular, why are you an expert in this field? The second stage covers the facts on which the expert's opinion is based. This will include both direct and indirect facts, i.e., facts on which the expert has personal knowledge, so you may have conducted an assessment, for instance, as well as facts on which the expert relies and is derived from other sources, so collateral witnesses, for instance, school reports, etc. Okay, and then the third stage deals with the expert's opinions and the reasons for those opinions set out in the Rule 36 notice and any joint minutes. So then what you'll do then is in the third stage of your evidence being led, you'll then go through your expert report, and also you'll go through the joint minutes, because now certain things will be common cause and no longer in dispute. Certain things will then be in dispute, and your advocate will then lead you through those things that are in dispute in some detail, because that's what the case is about, and that's where you'll have to explain clearly and logically why you hold a certain position and why your opponent's position is either wrong or misinformed. Let's look at some tips for experts on evidence in chief. A standard structure for the expert in evidence in chief from an expert, the examination chief and expert witness is, this is what the advocate should do: introduce the witness by name, occupation, and residence. 2, establish the academic and other qualifications of the witness, including membership of professional bodies. Establish the practical experience of the witness in the field of science concerned. Establish the reputation of the witness in the relevant field of science by reference to any publication or other professional achievements. Ask the witness about his or her expertise in respect to the precise subject under scrutiny by the court. That can sometimes be very important, where there's specific expertise called for. Allow the witness to state all the relevant facts on which the expert's opinions are to be based. If necessary, the facts should be stated as hypotheses or assumed facts to be proved by other witnesses. 5, ask the witness for his or her opinions and ensure that the reasons for each opinion are given fully. Put any contrary views to the expert for his or her comments. And 6, if appropriate, ask the expert what his or her opinion would be if the facts were different. In this situation, it's important that the expert is consistent and does not undermine their own evidence or that of other experts testifying for their part. So these points are directed, as you'll see, more at advocates, but it is useful for experts to be aware of this, because you can take from these points specific items that you will want canvassed in your evidence, which you can then raise when you're preparing to give evidence, raise with your advocate. So when you go to a consultation with your advocate, be forewarned or pre-prepared. For instance, let's take that point about the precise subject under scrutiny. If you have specific expertise in that field, specific training or publication or something to that effect, experience, bring that to your advocate's attention. Okay, and then the other points you will probably go through with the advocate, but just be aware of, basically, not all advocates will follow this thing in a blueprint type of form. Every advocate has their own style and their own approach that they have worked out, but it's useful for you to be aware of those 6 points in preparing for consultation. Okay, then cross-examination. Here we go. This is where the bullets really do fly. And if you do well in cross-examination, man, you can get a very good practice as an expert. An expert that I know I can rely on in a torrid cross-examination is a very valuable commodity, and the attorneys, believe me, see it the same way. However, if you fold under cross-examination, you probably won't be asked back. So that's the brutal truth. Okay, 1, cross-examination is a process which is specifically designed to pressure test evidence. In the case of expert evidence, this almost invariably means that either the factual basis of the expert evidence, the reasoning process informing the opinion, the witness's qualification as an expert, or a combination of these areas will be pressure tested. Certainly, if you're going to be cross-examined, those things will come up. In addition, and although less common, there may be attacks on the independence of the expert witness. That does come up, or his or her honesty. That's unusual, but can happen. Does happen. Okay, 2. Don't worry, those 5 areas we're going to look at in more detail, but that just to get them out there. 2, it is important that the expert witness not concede any point unnecessarily and simply due to relieving pressure. Okay, that's so important. A good expert witness needs a backbone. Where expert evidence is called, there is a very high chance that the outcome of the case will depend on the expert evidence. The key points of the argument must be correct. That's where you need to be meticulous when you prepare your expert report. The way to avoid making key concessions is to make sure that the argument is right from the outset, i.e., when the report is written. I would just add to what I've written there, just make sure, even at your meeting with your other expert, once you see their report, consider their position. If you need to amend your position for valid reasons, remember the points I made there. But don't just chop and change because you're under pressure. Having said that, where concessions should be fairly made, then the witness should make the concession. However, expert witnesses should be aware that the concession may have a devastating effect on the case. And that's, I'm talking about in the witness box. You really shouldn't have to make concessions in the witness box. It does happen. It does happen that you validly have to make concessions. But you should be forewarned. You should have, if you prepared properly, read your opposite numbers expert report, applied your mind, gone through the joint meeting. You will get cross-examiners trying to surprise you and put you under pressure and come up with picky things but in the main, your reasoning process should be there, and you should stand by it. Where you may have to change, remember what I said earlier, is if the facts are wrong, if your sort of almost the carpet gets pulled under your feet, from under your feet. So, you've prepared your report based on certain information, and it's put to you that information is false, or what if it were false? What would you say? Then you must comment fairly on that, and it's for the rest of the trial process to deal with whether that information that you've been given is correct or not. That's out of your hands. That's no fault of yours. There you may have to make fair concession. Well, look, if the facts are different, then yes, I would agree A, B, and C. But be careful when you do that as well. Don't give too much. Don't give anything away for free. You need to be fair, and you need to be unbiased as an expert so that the judge can rely on you. But you do not have to, that does not mean you just have to fall in with what the cross-examiner is wanting you to say. You must monitor very carefully what you concede. And if there's anything to be said to dilute that concession or other points that might militate against that concession, it is your duty to make those points. Okay. Then 3, unlike evidence in chief, where only non-leading questions are allowed, in cross-examination, counsel is able to put leading questions to witnesses. In other words, questions can be asked which require yes or no answers. So now this is different to leading the witness. Now when you're cross-examining, sort of the opposite rule applies. Now when you're cross-examining, you're almost putting words in the witness's mouth. And you'll find a good cross-examiner will give the witness very little leeway and will keep the pressure on by saying something along the lines of, you performed an operation on the 23rd of May, 2025. Not so? And the witness then says yes. And when you perform that operation at XYZ hospital. Not so? Yes. And the operation was, what did we say? Subtotal abdominal hysterectomy. Yes. So you're now closing down on the witness. And then you'll get into the details as a cross-examiner as to what happened. This procedure, during the course of this procedure, this happened. Then you go on to the injury. This injury occurred. And then you say, now I want to refer you to the standard guidelines for performing this type of operation. Have a look at these. Are these the guidelines? The witness says yes. And the guidelines require this, this, and this. And the witness says yes. And if you do this, this, and this, there wouldn't be an injury. The witness says yes. And you say, and therefore can we take it that because you performed this operation and there was an injury, you didn't follow the guidelines? You know, that type of line, that's how you probe. And it's the point I'm trying to demonstrate is when you're cross-examining, you'll cross-examine, a good cross-examiner will sort of hem you in with yes and no answer questions. How you handle them is important. You don't want to be seen to be avoiding the question. Let me just go through this and then comment a bit. Counsel are taught to conduct their cross-examination in a manner in which the witnesses are predominantly answering with yes or no answers. We are trained in that as pupils. We are taken on courses and trained how you do this, how you cross-examine, okay? 4, this means that there are occasions where the expert witness may feel trapped or boxed in. On such occasions, the expert witness should answer the question, but qualify the answer with a request addressed to the judge that he or she wishes to elaborate on the answer. The judge will almost invariably allow this. Okay, so in the situation where now you're being asked a whole lot of questions, yes, 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 and it's true, the answers are yes, but there's more that you want to explain. There's some context, or you need to qualify what you're saying. Don't get into an argument with the advocate. What you do is address your request to the court and say, answer the question, say yes, and then you turn to the judge and you say, but my lord, may I elaborate on that answer? And the judge will almost invariably say yes. And if the judge doesn't say yes, your advocate will jump up or should jump up to their feet and say, we want that noted, or put up a bit of a fight, and should also make a note that in re-examination, you will get a chance to elaborate on that particular point. Usually better if you elaborate then or there. But if the judge does say no, it's your advocate's job then to raise that point in re-examination to give you a chance to answer the question properly. Sometimes you will even get your advocate objecting to a line of questioning where the cross-examiner is not allowing you to explain and is kind of boxing you in unfairly. That can also happen. From your point of view, the important thing is listen to the question. Don't avoid the question. Answer it, and then if you need to elaborate, say, but I need to explain. Okay? Now, let's have a look at point 5. The specific areas of attack and how to deal with them are discussed below. So, as I said, there's some specific areas that I'll alert you to. As a general rule, however, the best preparation for cross-examination is to ensure from the start that a thorough and accurate expert report is prepared, which is structured in accordance with the principles governing expert evidence. This will allow the expert to formulate a robust argument which can withstand the rigors of the court process, including meetings with other experts, cross-examination, and questions from the judge. I just want to see if I've got anything on questions from the judge here. I just want to quickly make a point there on questions from the judge are very, very important. It shows you where the judge is coming from, and they need to be answered. They need to be answered fully, and they need to be taken seriously. You need to try, at that point, you've really got to work hard to persuade the judge. Okay, you've got to, and stay cool and think of anything that can help you to persuade the judge on that point to your point of view. It's so often, it's that question from the judge that when they ask that question, so often that's their view and it doesn't change. And everything else doesn't matter. It's very important to pay attention to those questions and deal with them properly. Okay, then I say, if the expert is properly qualified to give an opinion, the argument is correct and thorough in its assessment of the facts, a well-reasoned opinion is expressed, and the expert's opinion is presented in accordance with the procedural requirements governing expert evidence, which is not your baby, but assuming that if you're giving evidence, you should be there, then the expert witness will be well positioned to not only survive the cross-examination, but succeed with flying colors in persuading the judge that their opinion should be accepted. And that could be a tremendous high. Is to win a case and to win a cross-examination is a very, very rewarding thing. From a professional point of view, do you practice the world of good, and you can really come out on a high at the end of a trial if you're successful. 7, prepare for the cross-examination. Make sure that all expert reports which have been prepared and which will impact on the expert witnesses' evidence have been read and understood. So too should the expert minutes. Okay, so it's similar advice to the meeting of experts. Make sure you've prepared for it. Read the information, or reread it if you haven't for a while. Okay. Of particular importance are the expert's own Rule 36(9)(b) notices and any joint minutes signed by the expert. So anything you signed and your own notices, obviously. Experts should ensure that they understand the opinions and the reasoning process, as well as the facts and inferences giving rise to the opinions. That's very important. Understand that reasoning process. That is at the heart of this work. Okay. 9, ensure that any technical terms are either described in a glossary or are explained by the use of diagrams, reliable textbooks, or other literature. This is now, okay, we're moving to more the way you present it, but this is important because remember, as I said to you at the beginning of the webinar, the judge is you there because you've got technical expertise, training, experience that the judge doesn't have, and you are there to guide the judge. You're almost, in a way, an assessor and helping the judge on questions of facts. Okay, it's a very trusted position, really, being an expert. In order to, you can't persuade someone if they don't understand what you're saying. Okay, so where you're dealing with technical terms, make sure, go to some trouble to explain those terms. Especially when you get into a trial situation. Okay, maybe you know in your general work you're busy and what, but if there's a trial looming where you may actually testify, something along the lines of a glossary, you'll have to do it timeously. You can't just give it to your advocate on the day. It'll have to then be put up as some sort of notice, maybe agreed at a pre-trial conference or something between the parties. But if you could prepare some sort of glossary timeously would be helpful. If you can do a glossary in your routine reports, well, that's fine as well. But certainly just apply your mind to that and discuss it with your legal team. Remember that the judge, for the purposes of expert evidence, must be regarded as a lay witness. And will have to be educated on the technical aspects of the evidence. Any assistance which can be provided to the court in this regard will be appreciated by the judge and will increase the chances of the opinion being accepted. Experts should therefore include in their preparation giving some thought as to how technical concepts will be explained in lay terms. Expert witnesses should seek the assistance of counsel in preparing for cross-examination. This process will begin when the expert is first instructed and will continue to the point where the expert begins giving evidence. After the expert witness has given evidence in chief, the expert witness is on their own. So once your advocate's finished, now you're over to the lions, and the legal representative of the party instructing the expert may not discuss the case with the expert while they're under cross-examination. So the tea breaks and that, you can't say, listen, how must I deal with it? You can't say that. This rule applies to all adjournments of proceedings, no matter how short or long. So the case may not be discussed should the matter be part heard and the expert witness is still under cross-examination. Okay, let's just go through these last few points. Experts should pay particular attention to the underlying facts on which the expert opinion is based. It's very important that expert witnesses understand the reasons for their opinions thoroughly and to the point that they can clearly and simply explain in lay terms what those reasons are. Very, very important. 12, experts should ensure that their curriculum vitae is accurate and up to date. Please check it meticulously. Don't make that mistake. This should include any academic qualifications, practical experience, and publications. 13, bear in mind that cross-examining an expert is a challenging process for the other side's counsel. In most cases, the cross-examination will cover areas which the expert is very familiar with, but which probably will be new territory for cross-examining counsel. So remember, you do have that advantage. I've mentioned it once or twice. Be aware of that, okay? And then 14, demeanor in the witness box is extremely important. Expert witnesses should ensure that they remain professional at all times. This means that questions in cross-examination should be answered with tact, courtesy, patience, and guile. In other words, be clever how you answer your questions, but do it courteously, do it tactfully, be patient, okay? At times, cross-examination will cause the expert witness to have to exercise strict control. Some cross-examiners are downright irritating, okay? And they irritate everybody. But if they're irritating you, they're probably irritating the judge, okay? And it's your job to remain professional and composed, okay? Any loss of professionalism will negatively impact the credibility of the expert witness, sometimes disproportionately so. Even a slight loss of professionalism can have it. It's funny, it just undermines all your evidence. Okay. Remember that in a sense, the expert witness's character is being tested in order for the court to draw a conclusion as to the reliability of the expert witness himself or herself. Okay, those are the sort of practical pointers. I just want to take you now for our remaining time with the main areas of attack that you can expect in cross-examination as an expert witness, okay? Advocates are taught about these areas. Some of them are better than others at how they approach this. Some are very effective, but in general, almost all cross-examination, all attacks under cross-examination will fall within one or more of these areas. This does tend to cover everything, okay? And I give advice in the book on how to prepare for each of those areas of attack, as best you can. Sometimes you can't really prepare for the minutiae and every last detail, obviously. You don't know what's coming your way. You have to accept that going into a cross-examination is sort of unarmed combat. It's your wits against the wits of the advocate to an extent. But the advocate's going to come up with different things. Some advocates are very tricky. Some of them are very aggressive. Some of them very intelligent. It just depends on what you're dealing with. But at the end of the day, all you can do is really prepare yourself for the unknown. And the better prepared you are, and the better your reasoning is leading up to that point, the better you'll be positioned to deal with anything they can throw at you, and for you to come through with those flying colors that I talked about, okay? So the first area of attack is attack on the qualification and status of the expert witness. So this is one that you really shouldn't fall foul of it. But you've got to be very careful when you do your expert report that you are in fact qualified to express an opinion on everything in that report. It's actually quite easy meat to attack an expert on their status. In other words, they're not qualified to express a view in its entirety or a portion of that view. And then there are questions about, but surely you knew that this was not within your field of, you understand your field of expertise, Dr. So-and-so. You know that these things don't fall within your field of expertise. Why did you pass this off as something within your field of expertise? You see, there's an insinuation of dishonesty, and certainly an indication of unreliability by the expert. You're being fast and loose at best, and maybe a bit too full of, yourself. That type of insinuation. So don't fall into that trap. I just want to go to that second paragraph. With the passage of time, as the issues related to expert evidence have become more complex, there are subspecialities within particular fields on which a particular expert may or may not be qualified to express an opinion. Lines of attacking qualifications and status therefore include examining whether the expert is in fact qualified to express an opinion on the particular subject in issue, bearing in mind any subspeciality involved. That applies a lot more in medical malpractice cases where subspecialties are important. Can come up in RAF cases as well, though. Just be careful about your exact, that you are qualified to comment. If you're not qualified to comment, you must bring that to the attention of your legal team, and then you must, after that, put that in your report so that they can get an appropriate expert and you don't get exposed to this line of cross-examination, okay? I'll give some practical pointers here, but I'm not going to go through that because we're not going to have time. I was going to go through the main areas. 4.3.3.2, attack on the facts, assumptions, and conclusions on which the expert bases his or her opinion. This line of attack is essentially an attack on the premises of the expert's argument. Are the foundations correct? Are the facts, assumptions, and conclusions on which the report is based correct? Have all material facts been taken into account? Does the argument cover all the established facts and conclusions? So you're looking at the facts. I just want to take you, it's a bit of a long quote. I want to take you through this quote about Mr. Sandeman. I just want to take you to this paragraph at 210. I'm not going to go through the whole quote, but this is, let me take the paragraph before and this paragraph. It just demonstrates to you what can happen in the witness box if you don't get your facts right. This was an English case, but it illustrates the point quite well. It must therefore have been obvious to Mr. Sandeman, well before December 2018, that Mr. Battersby had access to medical records which he, Mr. Sandeman, said he had not had access to, and which therefore meant that he had reported on a false or at least incomplete basis. However, again, yet more astonishingly, Mr. Sandeman appears not to have drawn this to the attention of his instructing solicitor. And he told me that it was only in the week before trial, when he had access to the trial bundle which contained the full medical records, that he had access for the first time to the full medical records. He nevertheless went into the witness box and gave evidence affirming the accuracy and correctness of two medical reports, which simply did not stand up to a moment's scrutiny, given that they had been prepared on a false and wholly incomplete basis. In other words, this expert prepared expert reports based on only part of the medical records. He then was given the full medical records in the week before trial, and he still goes in the witness box and repeats the opinion which he gave in his report. And the judge says, I regret to say that, in my judgment, Mr. Sandeman's evidence fell far below the standard to be expected of a reasonable, competent expert witness, both in relation to the preparation of his reports and in relation to his preparing to give evidence. I could see no excuse for this whatever. And then so that, and you can go through this a bit more in that quote, which is interesting to read. But that's just to demonstrate how things can go wrong if you don't check your facts carefully. All right. I'll give some practical tips. We don't have time for that, unfortunately. But let's have a look at the next one. Attack on the expert's opinion and reasons therefore. So now this is on your opinion and reasons. The third line of attack in cross-examination is to attack the opinion and the reasons given. And there's a quotation there. It's a quotation from one or two cases. But the quotation I've given is the cogency of an expert opinion depends on its consistency with proven facts and on the reasoning by which the conclusion is reached. You've got your facts. What's your reasoning process? Further down, faced with a conflict in the expert testimony of the opposing parties, the court is required to justify its preference for one opinion over another by a careful and critical evaluation thereof. The evaluation of expert opinion in assessing its probative value and the considerations relevant thereto is determined by the nature of the conflict in the opinions, the context provided by all the evidence, and the issues which the court is asked to determine. In general, it is important to bear in mind that it is ultimately the task of the court to determine the probative value of expert evidence placed before it and to make its own finding with regard to the issues raised. So what this means is that reasoning process, so you've got your expertise is established. The facts are established. Now, what do you make of those facts? That's the reasoning process. And that is what the court will look at. And the court ultimately will form its own view as to whether that reasoning process is correct or not. It will not just simply follow what the expert says. Okay? Then I just want to get to the next main line of attack. Sorry, been talking for a long time. Next main line of attack, 4.3.3.4, attack for bias, interest, or dishonesty. The fourth line of attack is to attack the witness on more personal grounds such as bias, interest, or dishonesty. This line of attack is uncommon, but certainly can and does arise. Okay, I'm going to take you through dealing with how to deal with an attack for bias, interest, or dishonesty. It's not long. The prescription for this line of attack is to ensure that the test for lack of bias has been met, i.e. that the same conclusions would have been reached if the expert had been instructed by the other side. Allegations of undue interest or dishonesty should, of course, have no valid basis. So, all right, I think that I don't need to elaborate on it. And then attack for failure to comply with the principles and rules governing experts' evidence. Lastly, experts are cautioned to be familiar with the principles and rules governing experts' evidence set out in chapters 1 and 2. It is becoming more common for experts' evidence to be criticized on these grounds. There are a number of, there's one very high-profile case on at the moment where a senior expert is being criticized. That an AM decision is one where the expert was criticized. You saw that Sandeman case. As experts are moving more and more into the fore in court work, and they're doing this work, the courts are expecting a significant standard from the experts and for them to be familiar with their duties as required by the court. And if you don't comply and you don't present your evidence in a way that the court requires you to present it, the courts are making adverse remarks and findings about expert witnesses. Okay, let's leave that there. And then, so I think that wraps up the presentation. I'm just going to check to see whether there are any further questions. Just bear with me while I check this. Okay, I don't see any further questions. If there's anything anybody wants to ask, I'll give you an opportunity now and then we can wrap up. Otherwise, I will just go into wrapping up. Okay, I don't see any further questions. All right, just to conclude, that gives you a, I think, fairly comprehensive overview of the litigation process and of the various court skills which expert witnesses are required to have. Just remember the key points. Remember the process itself. Remember that it is you're going to locate your evidence within the context of the overall trial, and that you are there to assist the court and to assist your advocates to be able to, your advocate and your attorney to be able to, as part of a team, persuade the judge as to your point of view. So teamwork is important. That meticulous attention to detail on your expert report is important in preparation for trial. When you get to trial, your presentation and demeanor is important. Be professional at all times in what you wear, in how you conduct yourself, even when you're under pressure. Listen carefully to what your advocate is asking you. You should have been through that with your advocate already, and you should, there shouldn't really be any surprises. But remember that your advocate can't put words in your mouth, so try and figure out where your advocate is coming from. Some advocates are better than others at doing this. You may have an advocate who battles a little bit with this skill, so be there to assist your advocate. Under cross-examination, try not to get thrown too much. Don't fall into obvious traps, but if you've prepared your expert report, if you are in fact qualified, you've got your facts right, then at the end of the day, even if you get buffeted about a bit in cross-examination, your expert report should stand unless you are driven to making concessions. That's really the real, where there's a real problem, is if you have to start making concessions. That's unfortunate. And then once you've finished your evidence, your cross-examination, your advocate will have a chance then to help to deal with any questions that have been unanswered or patch things up if necessary. And then that will be the end of your involvement in the matter. The matter will proceed. Other witnesses will be called. There will be argument in the matter, and in due course there will be judgment. If you've acquitted yourself well on all of those tasks, you should do well as an expert. It is a robust process, litigation, and there are no certainties. But on balance, you should actually come through quite well, because there are not that many experts who can properly acquit themselves, and they are very valuable to the attorneys and to counsel, and we do work out who they are. We know who they are. Those are my thoughts and points. Finally, just remember, please get hold of Zita. Zita will take over the administration tomorrow. We will make the slides available. If you do want to buy the textbook, I think she's already put a link up. Get hold of us. I think we've got a bit of stock left. We're going to do another print run in the next week or two. So that would be good. And then I hope that you've got something from this. We will have other webinars coming up over the next few weeks. Just keep your eyes open for that. And then we've got quite a nice announcement coming up end of the month. We're partnering with quite a nice organization. And then there's a lot of growth ahead for the South African Medico Legal Reports. But with that, I just want to thank you all for your time and your effort and your interest. And hopefully that was of use to you, and we will be in communication with each other soon. I see somebody has got, okay. There's a question about the textbook. I'll just get Zita to answer. I think it's 1799 for the textbook, but I'll get Zita to deal with all of those details. All right. Thank you so much, everybody. Good night.